Okay, so let's talk about the questions. Looks like we have a lot of great questions here today. I'm seeing about 15 questions, so we're going to start right in with the questions. So the first one is, this owner would like a clarification regarding 33-18-18, which is Arizona Revised Statute pertaining to planned communities. An HOA with its CC&Rs recorded prior to 2014 with provisions prohibiting overnight street parking would not have that provision invalidated if an amendment on an unrelated issue, short-term rentals, was passed after the law went into effect in 2014, correct? It seems to me that logically only the unrelated amendment is being recorded, and this would not invalidate any other provisions of the CC&Rs, even if that last sentence refers to a declaration, and by official definition, any amendment is a declaration. Okay, so this is a great question. This is a gray area under the law. So several years ago, a new law was passed that said that regardless of what your association documents say, after the declarant is no longer in control, an association doesn't have authority to regulate roadways for streets that have been dedicated to a city or governmental entity. And it only applies to those planned communities for which the declaration is recorded after December 31st, 2014. Okay, so if you have an association that is a planned community and that their declaration was recorded after December 31st, 2014, so starting in 2015, the association cannot regulate on-street parking, if that street has been dedicated to a city, town, municipality, county, or another governmental entity. So the question is, this association had CC&Rs recorded before 2014, right? And so they're wondering, well, is an amendment that we did after December 31st, 2014, does that invalidate our parking provisions? Because technically, the amendment, it was an amendment to the declaration. Does this section kick in? I wish I could give you an answer on this. My inclination is no. Okay, but there's no court that has interpreted this. And the rationale for me to say, no, I don't think it invalidates the parking restrictions, in your CC&Rs because you did a short-term rental amendment after December 31st, 2014. Because the language in the statute doesn't say, it doesn't say anything about amendments to the declaration. I think the intent of this section was that this applies to new communities, new planned communities where the developer, is creating a new community after December 31st, 2014. So, but I can't give you a definitive answer because we don't know yet how court's going to interpret this. We kind of have to take a wait and see approach, but my inclination is that your amendment did not invalidate your parking restrictions. Okay, next question. My HOA has its annual meeting coming up shortly, and this question's from an owner. I've notified both the board president and our community manager of the requirements for annual meeting voting according to your cheat sheet. Specifically, ballots must be mailed to all members of the community. As of today, this still hasn't happened. That said, I've been told we're holding the vote for new directors via Vote HOA, an online service. Despite my squawking, neither the president nor the community manager have made provisions for mail-in ballots or hand-delivered ballots. I'm since told postcards with voting instructions will be mailed to the homeowners. Is the voting okay with Vote HOA only, or must we still provide a means of mail-in voting and hand-delivered votes? This is a great question. Actually, I just literally did an opinion letter on this morning prior to coming on this call. So the bottom line is that electronic voting is allowable under Arizona law. There are provisions, in the Planned Communities Act, the Condominium Act, that allows, boards to have electronic voting by its membership. But we also need to look at what the absentee ballot and mail-in ballot law says. And that law for planned communities and condominiums says that owners should be allowed to vote in person at the meeting, at the annual meeting or a special meeting of the membership, in addition to, the ability to vote electronically, through an absentee or mail-in ballot. So, what I would recommend for your association is, of course, they can use Vote HOA, which is, this online service, assuming that there's nothing in your bylaws that would prohibit something like that. And probably there won't be. But they should also, in the notice of the meeting, or maybe even on that postcard, say that if you choose not to vote using Vote HOA, you can vote in person at the meeting, or you can contact the office, the manager, whatever, and ask for a paper ballot. And then you can return that absentee ballot by mail if you so choose. So giving them options, I think, is the way to fully comply with the law. You got to be really careful on this, because it's a lot of associations just think when they use this online voting company that, they're just going to handle everything and we're not going to do in-person voting. Well, there's a problem with that, because the statute in Arizona for condominiums and planned communities says that owners should be given an opportunity to vote in person at the meeting. And if an owner elects to vote in person at the meeting, you have to let them do that. And then there's kind of that gray area that if somebody doesn't have the technology or doesn't want to vote using the online service, giving them a way to get a paper ballot by contacting a number is the right and appropriate thing to do. Okay, next question. In the board code of conduct cheat sheet, there's some language underlined, and I'm assuming that you're talking about our cheat sheet on code of conduct for a firm. The board cannot require directors to sign a code of conduct unless the association's documents require a code of conduct be signed. What's the reference that stipulates that the code of conduct need to be in the association's documents? Is it in Arizona law? Our board election is coming up and our management company is requiring candidates to sign a very restrictive code of conduct. And example of this would be no social media use, or, some other stipulations that they have in there. To be considered as a candidate, you have to sign the code of conduct, yet the association documents are silent about a code of conduct. How can I refuse the code yet run as a candidate? Okay, so really good question. So the code of conduct cheat sheet is something that our firm brings out when we're handling an extremely dysfunctional situation on a board. That's the reality here. There is nothing under Arizona law that requires board members to sign a code of conduct to run for the board or to serve on the board. If your bylaws, articles, or CC&Rs do not discuss a code of conduct, you or don't require it, you can't mandate that a candidate who is running for the board sign it. So your management company is stretching it in a big way, and I don't think it's enforceable. So you can refuse. The risk that you run on that is if you don't sign the code of conduct, they may not put you on the ballot for the annual meeting, meaning the board or the management company. I think they're wrong in not doing that, but you may have to go to, the Arizona Department of Real Estate, file a claim, have a hearing with, the Arizona Department of Real Estate with a administrative law judge to get you on the ballot. And I think you'll win, or you may have to file a lawsuit to get on the ballot. So I hope that your association's board recognizes that they can't do this. Really what they should be doing, on the flip side of this is, a majority of the board can just adopt the board code of conduct. You don't need unanimous consent of it. You can just, have a majority of the board adopt at a board meeting, hey, we're going to follow this code of conduct as a board. If one of the board members refuses to vote yes, or if one of the board members refuses to follow it, then of course, the code of conduct cheat sheet that we have is, it's watered down. There should be no objections to it. Basically, you have a fiduciary duty to act in the best interest of the association. You keep things confidential, avoid conflicts of interest. I can't imagine why a board member wouldn't agree to sign it, but sometimes they won't. So a majority of the board could adopt it. But, if you have a board member that refuses to comply with it, then you may have to think about removing the director under state law from their position as a director for the association. Okay, fourth question. Our board would like to raise dues, meaning assessments. Can this be voted on at the annual meeting, or is it to be done at a separate meeting? Is raising dues a vote decision by the board or by a majority vote at the meeting? So really good question. I'd have to look specifically at your association's documents to give you, an official legal opinion on this. But typically, there's a section in your CC&Rs that will talk about assessments, and it'll say, what percentage the board can raise the assessment without a vote of the membership. Usually it's a lower amount, like 5 or 10%. And what percentage you need a vote of the membership to increase the assessment rate above a certain percentage. So look at your bylaws, your CC&Rs. It should typically be in your CC&Rs. You can do this vote if it's a type of vote that's a vote that needs to be done as a meeting of the members. It can be done at the annual meeting, or it can be done at a special meeting of the membership. And so those are the different options that you have as you navigate this dues increase. Make sure you're talking with your association's attorney, and I think I am the legal counsel for your association, because you want to do it right. If you're increasing the assessment rate and you don't follow what your documents state, it could be challenged, and you may have to return all the money, due to the increase. So you want to make sure that you are handling it in a legally proper way according to your documents. Okay, another question from Facebook, from one of our Facebook viewers. Thanks for being here. The president of our HOA went door to door with another candidate and collected ballots when she was campaigning. Is this legal? To answer your question, is it legal? Yes. I mean, the board president, is an owner. They have a right to, go door to door and collect ballots. I guess the question is it a good idea? Would be my thing. So there's nothing illegal about it. But, if I were advising this association, I would, say there's nothing illegal about this, but it kind of looks bad, right? It kind of looks contrived, and like the board is trying to fix who's going to, be on the board, who they're working with. I'm not saying that there's anything illegal about it. I'm just saying it's kind of makes you think, like, why is there this much interest? And there may be very good reason. Maybe this person is a really qualified candidate, and the board president is going with this candidate to introduce them. I don't want to think bad in every situation. There could be a positive reason for this too, but it's unusual would be what I would say, and it's not legal. Question 6, would you recommend an HOA use the voting techniques to get opinions? You use a poll to get responses from your audience. General questions, city, role. If an HOA wants to get a general feel for residents' opinions on issue, do you recommend online questions? This is a really good question. Yes, I do. I think it's a wonderful idea, especially if you're having your meetings virtually and you want to get quick feedback from your owners and attendants, especially with larger associations where you have thousands of members and large attendance at your board meetings. So sure, I think that's a great idea. I also like the idea of using SurveyMonkey and polls, informal polls, just to find out how your residents feel about different issues. Next question. We have been informed by our HOA that we have a board member whose term will be expiring in April. We are due for an annual meeting in April. Is there a required number of days notice for annual meetings? Also, we have not been notified on how to submit a call for candidate vacancy. Should this process be done before the annual meeting? So we touched on both of these topics today. So good little refresher. So your notice of your annual meeting needs to go out not less than 10 days, not more than 50 days before your annual meeting. So there's a 40-day window where you send out that notice. Really, your board should have some procedure for looking for candidates to serve on the board if there's a vacancy on your board. Whether that is, sending out a letter to the membership, that's one way to do it. Talking about it at an open board meeting, having a nominating committee. These are all different techniques to get candidates to run for the board. Look at your bylaws to see if there's any specific procedure that your board should be following. Okay, should it be done before the annual meeting? Should there be a call for candidates? Of course. There should be some efforts by your board to get candidates to run for that one vacancy. Next question. Our bylaws mention eligible votes. Can you give an overview of what specifically that means. So it's hard for me to give that a summary of that unless I actually see how it's worded in your documents. But typically you'll look at your CC&Rs and your bylaws for your association, and it'll talk about the board having the ability to suspend the voting rights of an owner. And sometimes it's for non-payment of assessments. Sometimes it's for violations, on their property. Sometimes it's for any unpaid amount that's owed to the association, like fines or attorney's fees or late fees. So you really want to look and see how broadly or narrowly, not being in good standing for a person, to vote for your community. So, short answer, if I was, looking at this for your association and you were saying to me, how do we determine eligible voters? I would say, well, let's look at and see what your documents say. And let's say that your documents say that eligible voters are defined as people in good standing with the community. Okay, that doesn't probably help us too much, right? So then we go look at what the definition of in good standing is. And then it may say that there are no past due assessments or other charges owed to the association. In that case, then we get out the delinquency list and we determine who is in good standing and who's not in good standing. We recommend as a law firm to, prior to the, whatever the vote that you're taking that, they're going to be ineligible to vote for, notify those owners that are ineligible and give them a chance to bring their account current so that they can vote. So, somewhere either you're going to have, a notice, a special notice that's sent to them, or maybe even the ballot indicates that if, you owe any money to the association, you want to lift the language exactly however it's defined in your documents, that, you'll be unable to vote. If you have any questions as to whether you owe any money, please contact blank, and give them the opportunity to do that. Okay, next question, number 9. What are the requirements for an HOA management to update meeting minutes? Updated board roster. I have made requests for records and not received information in over 30 days. So I don't know if this person's on the board or if this person is a homeowner, but okay, so how quickly should meeting minutes be updated? So if there was a mistake on meeting minutes, the board will be voting on it at a board meeting and the changes will be made to the minutes. They'll be approved then by the board with the changes, and the management company should do it immediately. So within, a week or two of the board approving the revised minutes, that would be my best practices. How quickly should the board roster be updated? The annual meeting, within 2 weeks of the annual meeting, it should be updated and new information should be on the association's webpage, if that's where you keep it. You've also made requests for records, of the association, assuming that you're allowed to see those records under the statute and it's not one of the ones that can be withheld. The association and the board have 10 business days to get the records to you or to respond to you that, the records you're not allowed to see under Arizona law. So it sounds to me like things maybe aren't running well at your association. You might want to show them this video just to remind them of their responsibilities. Question 10. At the recent annual election, there were 2 board members, X and Y, up for reelection. Member X was reelected. Member Y was not. Member X found out that only 2 of the 5 existing board members voted for them. In essence, it appears that 3 of the board attempted to oust Member X. Member X happens to be the president. During the selection of officers, Member X offered to step down as president and have one of the others take over. They all declined. Any advice for how to proceed in this environment? So this is tricky. I wish I could say that this is isolated. We having such a large volume of associations that we represent, there is a small percentage where there's a lot of game playing and maneuvering. And so, if you're on one of those boards, it makes being on the board, serving on the board more difficult, no question, because, it's just maybe not everybody's acting solely for the purpose to have things be to the benefit of the association and to act in the best interest of the association. Maybe there's power plays going on, or maybe people have agendas. And so I think one thing is people are allowed to vote how they want to vote. I want to say that. So if three people don't want somebody to serve on the board, well, that's their prerogative. They have the right. They have that choice. It kind of concerns me that you somehow know how they voted, which means you probably looked at the ballots after the meeting. And to me, that's a little odd, I think, because, whoever gets elected, they get elected, and there shouldn't be any vendettas for how people vote. It is what it is. So, it sounds to me like maybe your board needs like what I would call like a boot camp. And our firm does this where we come in and we try to work with boards that have some dysfunction. And we talk about the issues that are causing the dysfunction. We talk about personality types and how different personalities on the board contribute to, the theme and the nature of the board. And we really try to work with you to get focused on what's best for the association and not all these petty disputes. So we really would recommend that for your association. We have come out a winner on every one of the boot camps that we've done over the past few years that we've been offering them. It's made a positive difference for many associations that had a high level of dysfunction, and they were able to move forward and put aside their differences and just get the business of the association done without a bunch of shenanigans going forward. Okay, next question. What is considered legal notice for a special meeting of the HOA under 33-1804? Okay, so there's a couple places that you want to think about. So is this going to be a regular board meeting, or is this going to be a meeting of the entire membership? So if it's a regular board meeting, it's going to be the 48 hours notice as required under the Arizona open meeting law for regular board meetings. If it's a special meeting of your entire membership, like for a removal of a director, or maybe to vote on an assessment increase or your annual meeting, you have to give notice at least 10 days in advance, but not more than 50 days in advance of that special meeting of the membership. Okay, next question, number 12. Since your last class, we have held our annual meeting. There we formed a parking committee with one board member and 2 community volunteers. We are also updating our rules, which were last revised in 2007. Can the group, including non-board members and volunteers, meet with the board in executive session? Or better, must we in an open Zoom meeting, as all regular meetings have been held in the last 24 months? Okay, so the question is, can the group, so I'm assuming that this is the committee, can the committee, can the group, including non-board members, meet with the board in an executive session? So it depends. Is this an executive session topic? Probably not. If it's parking committee, so I can't really imagine, unless there's advice from legal counsel regarding something on the parking committee or the parking rules, I can't really see this falling into a category that would be executive session. So I would recommend that you meet during the board's open meeting and give your report, which is really, the way it should be done so that owners know what the committee is doing. Let's see. Or better, must we in an open Zoom meeting as all regular meetings have been held? Okay, so you could also have this committee give a report during an open Zoom board meeting, which I think would be the best way to handle it, because this doesn't appear to be an executive session topic. Okay, next question. Should an HOA management contract and fee schedule be provided to members via written document request? This has been prohibited by past management firms, saying their contract is proprietary. Also, past boards have not provided it. Who decides? We have a new board and want to know how to proceed. Okay, so great question. So let's look at what documents owners are entitled to see as under the law, under the Planned Communities Act and the Condominium Act. So under Arizona law, the management contract is able to be viewed or copies made by an owner if they choose to make that request. The board does not have to provide compensation information as to how much you're paying the management company to the requesting owner, because that's something that you can withhold from disclosure. So it's my opinion the management contract should be provided to the owner if they request it. The board has the right to redact or blacken out how much the management company is being paid for various services pursuant to the management contract. But what we advise our clients is don't play hide the ball. We don't usually recommend that they redact anything from the management contract when they provide it to the owner. Why? Because there's so many other places that the owner can look to find out how much the management company is being paid. They can look at the budget. They can look at the bank statement. They can look at the financials of the association and figure this out. So why play hide the ball? It looks like you're hiding things. Now, the management company saying that their contract is proprietary is, unusual. The owners have a right to see it. And it's not like a trademark thing or copyrighted thing. I mean, it seems odd that they would be saying that. The associations that have problems are the associations that play hide the ball and cover up stuff like this. The associations that are freely providing information to their residents and not hiding things that people are interested in and want to know more information on, they're going to have fewer problems. So you've heard my take on it. I think you should provide the management contract. Why would you hide it? Okay, and if the management company is trying to, pressure you in any way, saying we'll sue you if you give up this proprietary information, I really think you need to escalate this to your legal counsel because that just isn't right. The management contract is not proprietary information. They were selected as a vendor for your community, and they've been hired. It's not like you're in the bidding process, and the number that they're bidding is, important for another management company to see because they might be able to underbid them. We're just not in that situation. So I don't at all understand why they're saying that the signed management agreement for the association is proprietary. Okay, next question from one of my favorite clients. When the board makes policy changes, we approve the change and then have the policy read at 2 meetings before implementation. This can be quite time consuming. Is there a preferred procedure for policies? Okay, I would say just knowing your association, because like I said, you're one of my clients, I believe you have this requirement in your bylaws. So you have to do it this way because your bylaws for your association require this. But 99.99999% of associations in Arizona do not have this requirement. And so this may be something that if it's becoming too time consuming and burdensome, this might be something that you're going to want to amend your bylaws or your rules to take this out so that you don't have to do this. Most boards discuss, whatever they're going to be discussing on a policy. If they adopt it, the homeowners are notified of the policy and that's that. Everybody moves on. You don't have reads through. It's not like, this is like almost a legislative process for your association. Most boards are significantly more informal. They vote on it, they notify the owners, they move on. Okay, next question. Does a proxy vote count from a board member to complete a quorum at a board meeting? No, it does not. If a board member cannot attend the meeting in person or virtually, they cannot give their proxy to another board member to vote on their behalf. Okay, question 16. It looks like we have 20 questions, so we've got about 5 more. We have no community center. Are we required to rent a venue in order to include all members, including those who do not use electronic methods? So I'm assuming that this question is asking, so we don't have a community center on our property. Do we have to rent a venue, maybe for your board meeting or your annual meeting, to include people who aren't appearing virtually or electronically? I think you have to look at, what's best for your association. So is this something where you have common areas where you could have it on the common areas? Is this something where you could go to a library and rent a room at a minimal cost? Could you just have it at somebody's home and, have a virtual setup, and then the people that don't have virtual access, they can come in person? There's no right answer here. Are you required to rent a venue to include all the members? No. But if members want to attend, listen, and participate, you need to give them avenues to do that under the open meeting law. So you'll have to just think about if you're having issues, finding a venue, should we be doing this all virtually? Should we be doing it hybrid? Is there a place in the community that's free that we could meet. A lot of associations just manage this without having to spend a bunch of money. So I think just really think long and hard. If you have any questions, you're welcome to call me too, and I can help you discuss this further. Okay, next question. Is a board member that issued a cease and desist letter to a resident legally allowed to share in part or whole any part of the cease and desist letter with other residents? So we typically see cease and desist letters where there's some sort of harassing behavior between owners maybe, or between maybe an owner and a board member, and a letter is sent saying, cease and desist from behaving in this manner, or maybe cease and desist from any contact with this person. Is it something that we would share with the community? It depends. In cases, yes, it is shared. If there's questions as to, what's going on, or maybe there's a high level of harassment, or there's misinformation being distributed throughout the community. But is it something that we normally share? Probably not. But there have been times where it has come up and it's needed to be shared to, provide response maybe to an owner who's maybe putting misinformation out there or whatever. Whenever you get into the cease and desist, so, it's usually there's a level of dysfunction in the association, and that's too bad. Hopefully we're hoping that owners and the boards can work together to resolve their differences, and most boards do. In another HOA, the board is meeting in small groups and making plans for things like assessments. They are trying to get past the open meeting law by discussing things in small groups, or by BCCing emails. Is that allowed? So if it's less than a quorum, meeting in a small group to discuss association business, yes, that is allowed. If it's less than a quorum, discussing things by email, yes, that is allowed, and you don't have to follow the open meeting law. If you're sending an email to board members and maybe one board member or less than a quorum, and then you're BCCing the rest of the board, be careful on that, because that sounds like a violation of the open meeting law. Next question. If an HOA has an annual meeting virtually only, how does the voting in person option apply? So really good question. We were writing an opinion on this morning for another association. So there's two ways that owners can vote in person at a virtual meeting. So the day of the meeting, there could be a location where the owner can drop off the ballot, maybe the community office, if you have one, a vote box that's, adequately protected and votes can't be taken from, having a place where they can deliver it. Maybe it's a board member's home. I don't know, you'll have to think about it. So that's one way to comply with voting in person when you're having a virtual annual meeting. Another way to comply is to have anybody who appears virtually at the meeting who wants to vote take a picture of their ballot and text it to a designated person. We did that in the pandemic, or email it to a designated person, and then that vote is added to the total count. Next question. I have not been allowed an email list of homeowners as the vice president of the association. I asked 10 business days and still didn't get it. I'm going to listen to this recording several times. Oh, this is excellent. Big thank you. Well, thank you very much for saying that. Okay, so email lists are it's a real tricky area for associations. So owners have an expectation that their property address at the association and that their names are public record. And that if an owner makes a request to see the name and address, property address of an owner, that is something that we would be required to give to, an owner if they requested it. Emails, cell phone numbers, home phone numbers, there's an expectation of privacy by the homeowners. And so if the association is collecting that information, the association really should be asking the owners, is this information that can be disclosed to third parties, or is this information that is personal information that should not be disclosed? That's, of course, best case scenario, that your board has that information and they already know how the owner feels about it. A good way to get that information is to ask that question on your annual meeting ballot and then put that in the owner's file. So, they vote, yes, this is private information. I don't want this disclosed, or this can be disclosed to anyone. I'm guessing that your association doesn't have a policy like that, and you just, by chance, you have an email list of owners. It is private information, personal information, in my opinion. So I can see that that information isn't being given to homeowners. You're the vice president of your association, and typically this information would be shared with all the board members. But if you're planning, to send out an email to these people by email owners, in your association, I think that is a breach of your responsibility or fiduciary duty to the association. So those emails could only be used to send out a communication that's approved by a majority of the board. And so that would be my take on this. Okay, last question for today. What is considered proper notice of a special meeting of the board? 48-hour notice under ARS 33-1804. How specifically should the board notify everyone? Can the website be used? Is an email blast appropriate, etc.? Okay, really good question. So if you're having a special meeting of the board, you're going to want to give the 48 hours notice under Arizona revised statutes. And you can give that notice of meeting to a special meeting, by putting it on your website. You can send an email blast out. You can post it in your common areas, but everything, it needs to be sent at least 48 hours in advance of the meeting. Thanks again for joining us today for class number 3 of our 2022 Virtual Condo and HOA Academy. I want to thank again the neighborhood service departments from the cities of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Phoenix, Scottsdale, Surprise, and Tempe for your teamwork and continued partnership with Mulcahy Law Firm to put together these amazing virtual classes. These classes are providing free education for hundreds of board members, managers, and owners throughout your cities. And I think you can see from the number of questions that are asked and from the participation here today that these classes are really needed and appreciated by the residents of your respective cities. Don't forget, a couple reminders. We have our next live virtual First Friday event on April Fool's Day. I wonder if we're going to be doing any April Fool's jokes on you. And we're going to be answering questions for free live starting at 9 a.m. on Zoom and Facebook Live. If you want more information on this, you can go and check our website at mulcahylawfirm.com and click on our upcoming seminars. We're also going to be doing 4 classes with the city of Chandler coming up here starting on April 13th and into May. So check out our website for information. Those classes are going to be in person. And of course, we've got our virtual class every month with the neighborhood services departments from around the valley. And class number 4 in April is going to be held on April 19th at 11 a.m. on Zoom and Facebook Live. And we're going to be discussing people problems and how to handle difficult owners and disgruntled owners and difficult situations in your associations and all the different people problems that come up when you're managing associations, serving on your board. Maybe you're a homeowner that's having problems with your board. Maybe your board's difficult. So we're going to cover all these topics and more. And I hope you'll join us for our next class number 4 of our 2022 Virtual HOA Condo Academy on the 3rd Tuesday of April, April 19th at 11 o'clock a.m. Thank you so much for joining us here today. We appreciate you being here, and we'd be so appreciative if you enjoyed the presentation today. If you would take the time to give us a review on Google, Yelp, or Facebook, and that allows us to get the word out that these classes are beneficial and helpful to many owners and board members and managers. So again, if you wouldn't mind, we would appreciate very much a nice review of the classes on Google, Yelp, or Facebook for Mulcahy Law Firm, if you're so inclined. So thanks again for being here today. Everybody have a great month. Happy St. Patrick's Day, my absolute favorite holiday of the entire year. My dad back in Wisconsin is planning a whole week of St. Patrick's Day events. So I'm looking forward to celebrating St. Patrick's Day this week with a green beer and some corned beef and cabbage, even though I'm the only one in my family who will eat it. But anyways, hope you all have a great St. Patrick's Day, and I look forward to seeing you again next month. Take care, everybody. Be safe and have a great week.